In today's video, we're going to discuss the 6 reasons for a denial contained in the Notice of Compensation Denial form in Pennsylvania that the employer may rely upon on trying to deny your workers' compensation claim. My name is Frank Lafferty. I am a partner with the law firm of Norfleet and Lafferty. We represent workers' compensation claimants and Social Security disability applicants. Now, as you can see, just generally I have a picture of the whole Notice of Compensation Denial form up on the screen. I'm not necessarily concerned with some of the other aspects of that form for this video. We're going to delve in only to the 6 reasons why the employer is trying to deny your benefits. But I wanted to give you an idea of what that form looks like. Most of the bureau forms resemble one another to a certain extent, but this one is going to be, what we talk about is going to be the Notice of Workers' Compensation Denial. So as we get right into the form itself, you can see that the highlighted part says the employer insurer declines to pay workers' compensation benefits to claimant because, and then there are 6 boxes there. We're going to discuss these individually. However, please note that the employer certainly could opt to have multiple bases for their denial. So they don't have to just pick one. There could be multiple reasons why they're denying your claim. So as we look at the first one, it's going to be that the employee did not suffer a work-related injury. The definition of injury also includes aggravation of a pre-existing condition or disease contracted as a result of employment. So essentially what the employer is saying here is that you were not hurt at work, that you just weren't hurt. You can establish that you were hurt clearly by showing that you fell down, you broke your knee, something along those lines. But this is where they're just indicating that maybe you were hurt at home, or that you just did not suffer an injury. The reason that box 1 is very important is that it does go on to say that the definition of injury includes an aggravation of pre-existing condition. Very often people will come in and say, well, Frank, I had a bad back already. I was moving a patient. It just feels a little bit worse than usual, but I know I have a bad back. Well, if you had back strains or back sprains in the past, maybe a bulging disc, and now you move that patient or you pick up that freight and now you've herniated that disc, you've aggravated that pre-existing condition. And that aggravation will be accepted or should be accepted as a work injury, because the definition of an injury does include an aggravation. So it's important to realize that when they're indicating that you did not suffer a work-related injury, if it's on the basis of an aggravation, that you discuss it with your doctor to see if in fact it has been made worse. And then if that's the case, you would be able to overcome that basis for the denial. The second box here is that the injury was not within the course and scope, or is not within the scope of employment. Course and scope is a highly litigated area of workers' compensation law. You're usually going to be looking at 2 certain situations as falling within course and scope. It's when the employee, whether or not on or off of the employer's premises, is injured while engaging in activity that is furthering the business interests or the affairs of the employer. The second one would be where the employee, although not engaged in furtherance of the employer's business or affairs, is 1, on the premises, occupied, or under the control of the employer. 2, is required by the nature of their employment to be on the premises where they're hurt. Or 3, where they suffered an injury caused by the condition of the premises. So those are 3 ways also to get within the course and scope of employment. Now, keep in mind, there is a ton of litigation about course and scope cases. So when you see that box as the basis for the denial, it's very important that you speak to someone. Number 3 says that the employee was not employed by the defendant. Now, let's keep in mind that an employee, the definition of an employee is synonymous with servant, and it includes all natural persons who perform services for another for valuable consideration. Okay? So if you're performing tasks and being paid for it, you will traditionally be deemed an employee for workers' compensation purposes. When they're checking off a box 3 denial, you are usually looking at someone who may be deemed to be an independent contractor. Independent contractor versus an employee, it is different because with an independent contractor, you are not an employee because of the absence of that master-servant relationship. Okay? And there's going to be key factors to determine whether you're an employee or an independent contractor. For example, the terms of the agreement between the parties. Is it saying that you're an employee, or is it calling you an independent contractor? Are they providing you with a 1099? The second one would be the nature of the work that is being performed. Third would be the skills that are required to perform the work. A few more would be which party supplies the tools, and is payment done on a by time basis? Do you get paid by the hour, or are you paid by the job? And then lastly, one of the more important rules is whether or not the person for the work, who the work is being done, retains the right to terminate your services. That's going to be a very important factor in making a determination as to whether or not you're an employee or an independent contractor. These denials come up very often with truck drivers. Very often over-the-road drivers are going to be forced to be independent contractors, despite the fact that some of these key factors do go both ways by virtue of an agreement that they've made with their employer. So if you're looking at a Box 3 denial, especially if it's based on an independent contractor, it's important to make sure that all of the elements of your employment are discussed and considered before just accepting this denial on its face. Now, as we move forward, the next box is Box 4. Box 4 states that the employee has not suffered a loss of wages as a result of an already accepted injury. Now, there we're looking at a good scenario would be where someone breaks their wrist, for example. They pay for your medical benefits, and you work in an office, and you're able to do all of your job tasks without any wage loss. That would be the basis for that sort of a denial. You fall down some stairs, you break your ankle, you're in a walking boot, and there's no need for you to miss work. That would be a basis for that type of a denial. So you have to realize that for workers' compensation purposes, disability equals wage loss. So you have to sustain a wage loss by not being able to do your job tasks because of the work injury. If you're able to do your tasks, then they're going to deny your claim for disability benefits or wage loss because you're able to do your position. So that's what we're looking at with a Box 4 denial. Box 5 indicates that the employee did not give notice of his or her injury or disease to the employer within 120 days within the meaning of Sections 311 through 313 of the Workers' Compensation Act. Now, let's keep in mind, we've talked before that the employee has the affirmative duty of giving notice of their injury within 120 days of that injury. So you're moving something, you hurt your back, you have 120 days from that time to tell them about your injury. The second part of Section 311, though, goes on to provide about notice about other types of injuries where you maybe have a dormancy period. Things like emphysema or mesothelioma or even some kind of cancers. With those types of conditions, the employee would be held to 120 days from the date they knew or should have known about that condition. So there's two aspects to that notice provision with the 120 days. If you hurt your back on January 1st and then you don't tell anybody until June, well, at that point they're going to certainly deny your claim for inadequate notice. But if you have one of those other conditions and you find out about it and you tell within 120 days, then you're going to be okay. And then lastly is the Box 6 denial, other good cause. Please explain fully in the space below. Now, I think I probably speak for every claimant's attorney when I say the Box 6 denial is usually the most frustrating. It's an opportunity for adjusters or insurers to string you along, to not necessarily be denying you for in a good faith manner or for a good reason. Very often they're going to try to point the finger at a doctor's office not giving them a medical record or something along those lines. And quite frankly, on its face and standing alone, a Box 6 denial is going to be the weakest. But you will see them often. It's usually going to be in conjunction with the failure to have certain documentation on hand within the 21-day notice period, or the denial period, and that's going to be tagged on to one of these other denial boxes. So there you have it. Those are the 6 reasons that an employer or an insurer can wind up denying your claim on a Notice of Workers' Compensation denial form. Keep in mind, if you do get the denial in the mail, it is not the end of your claim. It is not the end of the world for you. It's important at that point that you call and discuss your claim and your rights with an attorney. You go over the basis for the denial and the reasons why you are entitled to benefits, and you enforce your rights through the claim petition process. I hope this video was helpful. My name is Frank Lafferty. I am a partner with the law firm of Norfleet and Lafferty, and we represent workers' compensation claimants and Social Security disability applicants. We hope you take the time to look through some of our other videos, and hopefully they will be helpful to you as well. I can be reached directly at 717-737-7574. Or you can feel free to email me at fjl@norlaflaw.com. As I mentioned before, very often the ideas for these videos will come from emails, people with questions, and we're more than happy to try to answer your question as specific as possible. A lot of these videos are more general in nature, but we are always happy to have a very specific topic if there's a need out there. So please feel free to contact us.